Return to Work Act 2014 has brought about some changes in the way that medical treatment and medical expenses are going to be paid for workers who have sustained both old injuries, that is existing injuries prior to the 1st of July 2015, and also injuries from the 1st of July 2015. Under the old scheme, workers were covered for reasonable medical treatment for life. That is no longer going to be the case, and under the transitional provisions from the new legislation, workers with existing injuries are only going to be covered for a minimum of 12 months or a maximum of 3 years for their further medical treatment that they need. There is, of course, the exception to that, and that is if a worker is going to be categorised as a seriously injured worker, and then their medical treatment will continue to be covered for life. For the most part, when a worker's 12 months or 3 years is up, then the likelihood is that they will have no more medical treatment, no more medical expenses entitlements. The new legislation, the Return to Work Act 2014, makes it very clear that workers need to seek pre-approval for things that they want to be paid for after the end of their claim. For example, a worker who knows that they're going to need a knee replacement in 5 or 10 years' time can seek approval before their 12-month or 3-year medical expenses entitlements run out. And therefore, if you don't seek advice early on, you may well miss out on getting that pre-approval and therefore miss out on having your medical treatment that you need paid for. In comparing the old Workers' Rehabilitation and Compensation Act to the new Return to Work Act, workers with existing injuries, it is certainly a loss for them. That is, the new scheme is cutting off an entitlement which never was going to be cut off under the old scheme. Under the new scheme, the Return to Work Act for new injuries, that is certainly a loss as well, because workers are not going to be able to have all the medical treatment that they should have for their work injuries. We now have a new South Australian Employment Tribunal. This tribunal is set up to deal with all disputes from the 1st of July 2015. Existing disputes which were dealt with under the Workers' Compensation Tribunal will continue on in the Workers' Compensation Tribunal and will not transition over into the new tribunal. But eventually the Workers' Compensation Tribunal will run out of disputes and will ultimately be disbanded. The new South Australian Employment Tribunal is set up to deal with disputes more efficiently than has presently been happening. There are very short timeframes for lodging a notice of dispute from when you get a decision that you're unhappy with to the first initial directions hearing, followed by only one conciliation conference, followed by referring the matter to hearing. So if at any stage in your claim you receive a determination that you are unhappy with, you should immediately seek advice and make sure a notice of dispute, as it used to be known, or an application for review, as they are now known, is lodged as soon as possible. For workers who sustain injuries, existing injuries under the Workers' Rehabilitation and Compensation Act and are then transitioning onto the Return to Work Act, there is no doubt that they are being severely disadvantaged by the new laws. Given that they don't have access to the new lump sums that are payable and are still going to be subject to the cut-off dates that are going to apply for their weekly payments and their medical expenses, they are going to find themselves high and dry with little option unless they've been able to return themselves to work. For workers under the new scheme, that is the scheme operating from the 1st of July 2015, who sustain injuries from that date, there are still harsh aspects of that new law. There is still the cut-off dates that are going to apply, but they do get an extra lump sum to try to compensate them for those cut-offs applying. I think as a whole though, the new laws are harsh to workers. They have to be to achieve the government's outcome of saving money.